Employees and employers, you can be liable for a sexual harassment claim if you work in the state of Texas. It does not matter what position you hold in the company. Even if you are just an employee, even if your company has one employee or more. This law will become effective as of September 1st, 2021. What does that mean for your company? It all comes down to the definition of employer as defined by the state of Texas. An employer is a person who employs one or more employees. Because of this, all employers in the state of Texas may be held liable for sexual harassment claims under this code. This new Texas law also states that an employer may commit an unlawful employment practice if sexual harassment of an employee occurs and the employer or agents, 1, know or should have known that the conduct constituting sexual harassment was occurring, and 2, fail to take immediate and appropriate corrective action. Now, there's nothing in the law that determines what is immediate and corrective action. Another definition for sexual harassment purposes only, the term employer. It also includes any person who acts directly in the interest of an employer in relation to an employee. And because of this, on September 1st, 2021, supervisors, managers, HR professionals, vendors who are acting directly in the interests of the employer may be personally liable for a sexual harassment claim. And all these individuals may be held personally liable for any damages. Also, the statute of limitations has lengthened with regard to reporting sexual harassment claims. It was at 180 days, and any claims on September 1st, 2021 and beyond will have a statute of limitations of 300 days. So if your sexual harassment claim was prior to September 1, you will still have the 180 days. Anything September 1 and after will be 300 days, a statute of limitations. So what can your company do now? My advice is the following. No matter how small your company is, I advise all employers to have at least one person in that company that is well versed or at least have some intermediate knowledge of the sexual harassment laws in the state of Texas. Create and or revise your current employment policy on sexual harassment, taking into account the new laws that have passed. Create a process for your employees to be able to report any type of alleged sexual harassment claims. Training, training, training. Train your employees. Train everyone who works for you or who represents your company on your company's sexual harassment policy, on how the sexual harassment laws from September 1st on may affect them personally. Train your employees on how to report an alleged sexual harassment incident, and for managers, how to deal with sexual harassment complaints. Train your managers on your sexual harassment investigation process. And if you don't have one, you need to get one. Provide immediate investigations on all sexual harassment claims and take appropriate corrective action. Business owners, I highly recommend you do your own research in this area and keep a hands-on approach when it comes to any sexual harassment claims brought forth by an employee. And remember, all employees, including business owners, may be held personally liable for any sexual harassment allegations. If you have any questions, please leave your thoughts in the comment section below, and I advise you to talk with your licensed employment attorney on these new laws. Again, this is in the state of Texas. Thanks for watching. If you want to know more about business operations, business management, human resources, and other topics related to running a business, click on one of those play links. Click on one of these click on the playlist.
One eternity later.
Click on one of these playlists. Thanks for watching. And don't forget to subscribe.